that there is some talk that somehow the Court of Appeal decision in Alberta a couple of days ago that some of you may know about somehow is not dispositive of this issue. It is. Let's be clear. The very thing that this government wishes to do with the clause that Brigitte talked about, reasonably foreseeable natural death, is to limit it to terminal patients. The court explicitly did not accept that in Carter, and unanimously a couple of days back, the Alberta Court of Appeal rejected that as being not sufficient. So it's not a bunch of lawyers differing on how many angels can dance on the head of a pin. This is the Quebec Bar Association, the Canadian Bar Association, Jocelyn Downey, a noted expert in law and medicine. Joseph Arve, the leading constitutional lawyer in the private sector, argued more cases, including this one, in the Supreme Court than any other lawyer since the Charter's advent, all of whom are certain it's unconstitutional. So I'll challenge the government as follows. If you are so sure that this law is constitutional, you are uniquely able to do what's called a reference to the Supreme Court of Canada. Do it. Why cause suffering people like my constituent who isn't at end of life, but who otherwise would qualify under Carter? Why require him to go through the time and expense and frankly the agony of going back to the Supreme Court? You've never shown us an independent legal opinion. It was your Department of Justice lawyers who lost in Alberta last week and in Carter in 2015. Why continue the suffering? Why bring in a bill that most experts agree is unconstitutional? Why? When the fix is so simple, just use the language of the Supreme Court. Why? It is beyond my comprehension why we are even here.